with the amount of drugs you had, even though it was reduced to possession, felony drug court may not accept you. I can revoke you and I will sentence you to 4 years in the prison. So it's completely up to you.
Welcome to the Court of Justice.
Court is going to call 2022 CR 9686B, State of Texas versus Betty Jean Gonzalez, aka Betty Jean Gonzalez, one with a Z, one with an S. All right, can I have parties announced for the record for the state?
Hank Wilkins for the state, Your Honor.
Defense.
Jump as for defense.
And are you Ms. Gonzalez?
Yes, ma'am.
Showing you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that document with your attorney? Did you understand it?
Yes.
Okay. Are you saying Betty Jean Gonzalez, who was placed on deferred adjudication in 2022 CR 9686B for the offense of possession of a controlled substance, penalty group 1, 4 grams to 200 grams on February 2nd, 2023 for a period of 10 years? Is that you?
Yes, ma'am.
All right, state.
Yes, ma'am. Violated condition number 1 on or about the 6th day of May, 2023 in Bexar County, Texas. The defendant, Betty Jean Gonzalez, aka Betty Jean Gonzalez, committed the offense of possession controlled substance penalty group 1 in violation of condition number 1. And actually, Judge, if I could make an oral amendment to this, this doesn't allege the amount, but it should be possession.
Oh, you don't need to
Okay.
put the amount in, counsel.
Okay. Sorry, Judge.
Oh, no problem.
And we waive the other violations.
All right, to violation of condition number 1, how do you plead, true or not true?
True.
And with regards to the state's waivers, defense, do you have any objection?
No objections, Judge.
All right, did you understand by pleading the violation of condition number 1, the court could find it true, grant the motion, find you guilty, and sentence you up to 20 years in prison and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 1?
Yes, ma'am.
Court will find violation of condition number 1 true. Is there an agreement?
There is, Judge. I've spoken to defense counsel and Deshaun with probation, and we'd like to refer the defendant to felony drug court, Judge. And if she's not accepted in the felony drug court, we'd like her to go to inpatient, either SATF or safety, Judge.
All right, defense, is that the agreement?
It is, Judge.
All right, Ms. Gonzalez, are you asking the court to follow that agreement?
Yes.
Are you waiving your right to appeal?
Yes, ma'am.
All right, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand. Would you state your name for the record?
Betty Jean Gonzalez.
All right. So, Ms. Gonzalez, you know yourself better than I do, better than your attorney does, and better than probation does. If you want the treatment and you have a drug problem, I will most definitely refer you. I'll deny the motion, refer you to felony drug court. If felony drug court doesn't accept you, then you will be accepted into an inpatient treatment facility. But you know whether you can do this or not. Now, with the amount of drugs you had, even though it was reduced to possession, felony drug court may not accept you. And that's based upon the amount of drugs you have. Do you understand?
Yes, ma'am.
Now, so I can do that, or if you would like, I can revoke you and I will sentence you to 4 years in the prison. So it's completely up to you. When people want help, I want to give them help. I want people to do better. I note that you have people in your life, probably young people in your life, because I ordered parenting classes for you. But if you're not ready to take the help and ready to really work hard, because you're going to have to work really hard to maintain your sobriety, to not pick up any more cases. And I know with the possession less than, with a possession penalty group 1, I know the only difference between that case that you have and not having it is the fact that you didn't get a chance to use it. So I understand that. So what would you like to do? If you would like to discuss it with your attorney, you can. But you know yourself better than I do and he
So
does.
I do need the help.
All
I
right.
really do want the help.
So you want the help?
Yes, ma'am.
All right. So I'm going to give you the help, but you're going to have to make better decisions. When things happen in your life, the go-to can't be, I'm going to go out and get drugs, because otherwise what's going to end up happening is you're going to have another case and you're going to be back before me. You understand?
Yes, ma'am.
All right. The court will deny the motion, alter and amend conditions to do a referral to felony drug court. If not accepted, then inpatient treatment, either at, if probation, if you're recommending SATA for safety, all right, that'll be SATA. And if SATA doesn't accept her, then it will be ISF, cognitive and substantive track. And this is to happen while in custody. If you are accepted in felony drug court will be the person that is over your probation. The only time you'll come back to me is if you are unsuccessful, or if you're coming back to me asking me to appear at your graduation.
Yes,
And
ma'am.
I always, if I'm in town, I will be at your graduation, okay?
Yes, ma'am.
All right. Thank you. And state is dismissing the other charge. There you go. All right. Is there anything else?
Nothing from the defense counsel.
Probation, is there anything else she needs? All right. Thank you. Good luck. Court is calling 2020 CR 4185 State of Texas versus Daniel Antonio Swingle. Could I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Jim Oltersdorf for Mr. Swingle.
Are you Mr. Swingle?
Yes, ma'am.
Is that how you pronounce your last name? Swingle. Okay. All right, Mr. Swingle, I'm going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision, and state's motion to supplement pending motion to enter adjudication of guilt and revoke community supervision. Did you have a chance to review those documents with your attorney, and did you understand them?
Yes, ma'am.
Are you the same Daniel Anthony Swingle,
Yes, ma'am.
who was placed on deferred adjudication in 2020 CR 4185 for the offense of possession of a controlled substance, penalty group 1 gram to 4 grams on June 5th, 2020 for a period of 5 years? Is that you?
Yes, ma'am.
All right, state.
Violated condition number 5 in Bexar County, Texas. The defendant, Daniel Antonio Swingle, did then and there fail to report to the supervision officer as directed for the months of July, August, September, October, November, December 2021, January, February, March, April, May, June, July, August, September, October, November, and December 2022, and January, February, March, April, May 2023 in violation of condition number 5.
All right, how do you plead to that? Guilty?
Guilty.
I'm sorry, true or not true? No, the reason what is throwing me off is I just looked at this and I saw that this came from, I think this came from the 290th, because Jennifer Pena is listed. So I guess it got transferred here. I'm sorry. How do you plead to that? True or not true?
True. Your Honor, state waives all the violations.
All right. Any objections?
No, Your Honor.
All right, Mr. Swingle.
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 Oh,
Okay. Mr. Swingle, did you understand by pleading true to violation of condition number 5, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in prison and up to $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 5?
Yes, ma'am.
Court will find violation of condition number 5 true. Is there an agreement?
Yes, Your Honor. The agreement is for 2 years TDC. The state's also going to take into consideration it's a misdemeanor cause number. I don't have that misdemeanor cause number right in front of me, but I think Hank is going to write up the dismissal right now.
All right, is that the agreement?
It is, Judge. May, if we can be heard at some point.
Yes, you can be.
Well, you're probably concerned about that assault. It's refreshingly 2 males. My client basically got into a fight at the jail. So it's not a male and a female, which is good to know. I haven't had one of those for probably a year. Again, hasn't been good at all about reporting, but his record is not bad at all. That's why the state has presented a recommendation to you of 2.
Okay.
We realize, and Mr. Swingle realizes and is concerned over the fact that he's on deferred and full range is punishment is available to the court. So we're deeply concerned about that, but we're hoping that the court will follow that recommendation. Again, we've examined, both myself and the DA examined his record. It's not bad. When he was arrested again this time, he didn't resist, he didn't evade, he didn't do anything that would cause any problems. He wasn't caught shoplifting, for example. So we're just hoping the court will go along with the 2.
Okay. Mr. Swingle, is there anything you wish to say?
Yeah, I got 5 kids, so
5 children. Remember, kids are baby goats.
yeah, I got 5 kids. I got a wife.
5 children.
5 children.
Yes.
5 children. I'm trying to go home to and just working hard to change my life. Really am.
Okay. All right, the court will follow the agreement, sentence you to 2 years in the prison, give you credit for any time served. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to your attorney. You understand?
Yes, ma'am.
All right, we can go off the record. So were the tattoos painful?
No, I mean, the side of my arm was because I got the scar right here. So,
Mhm.
but not really.
Are you going to get
I
any
didn't
more?
hurt the most.
All right. Oh, and why did you do that?
I don't know.
All right, so you have a felony conviction. I'm sure your attorney has told you now, if you were to pick up any more criminal cases, you would be known as a repeater, which means whatever level felony that is, the punishment range would increase by 1 level. You understand?
Yes, ma'am.
You say you have 5 children, then you need to do better by them. You understand?
Yes, ma'am.
All right, good luck to you.
Thank you for hearing us.
Thank you.
The atmosphere in Judge Stephanie Boyd's courtroom is thick with tension as the case of Betty Jean Gonzalez is called. Gonzalez is no stranger to this judge, having been placed on a staggering 10-year term of community supervision in February 2023 for possession of a controlled substance. The mercy she was shown then has evaporated. The state, represented by Hank Wilkins, alleges that by May 6, 2023, a mere 3 months later, Gonzalez committed the exact same offense, a blatant violation of the most fundamental condition of her probation. Judge Boyd, with unwavering authority, lays out the motion to revoke her probation. She confirms Gonzalez's identity and the details of the original case, establishing the grave context. Then comes the critical moment. The judge asks for Gonzalez's plea to the violation, true or not true. In a move that admits guilt but gambles on mercy, Gonzalez utters, true. But Judge Boyd does not let this plea pass without a severe and deliberate warning. She ensures Gonzalez understands that this plea empowers the court to find her guilty, revoke her probation, and sentence her to the full range of punishment, up to 20 years in prison and a $10,000 fine. This is Judge Boyd ensuring the record is clear. The defendant is walking to the edge of a cliff. After finding the violation true, the court shifts to sentencing. An agreement has been reached between the state and the defense, but it is Judge Boyd who wields the gavel. Instead of imposing the decades in prison she just described, she follows a negotiated path focused on rehabilitation, but under her strict terms. She destroys the notion that this is a simple second chance. Judge Boyd orders a referral to the rigorous and demanding Felony Drug Court program. This is not an easy out. It's a highly structured, intensive alternative with zero tolerance for failure. Furthermore, she dictates a strict backup plan. If Gonzalez is not accepted into drug court, she must immediately enter an inpatient treatment facility. Judge Boyd's ruling is a devastating critique of the defendant's actions, offering a narrowly constructed path to redemption that hangs by a thread over the abyss of a 20-year sentence. Her final words deny the motion to revoke for now, but the altered conditions serve as a stark ultimatum. Succeed in this strict program or face total destruction of your freedom.